Resolution Centre.
Recording in progress.
We're very pleased to see a very large number of participants here taking part in our mock arbitration, which is organised by the London Maritime Arbitrators Association in conjunction with the IDRC and Opus 2 and Barristers Chambers 20 Essex and 4 Pump Court. You will hear this morning and be able to see a very realistic portrayal of a real-life arbitration hearing as conducted in London. And as I say, from the splendid new premises of the International Dispute Resolution Centre, which have been opened this week, where the centre is able to conduct simultaneously 18 hearings together with also public hearings. These are really state-of-the-art premises and facilities, and will be a great credit to London as the world's leading centre of arbitration. A few housekeeping matters, some of which you will see on the chat as to how to manage the video on screen. We have said that we will take questions and answers. Time will be fairly short, and we will aim to finish promptly at 12 o'clock. But we hope to be able to take some questions and answers, for which you should use the Q&A facility on the screen, not the chat box. We will look through the Q&A and try to take as many of these questions as we can at the end, but time may be short. And if time does not allow it, then we will try to answer some of the questions offline after the mock arbitration has concluded. After my introduction, there will be a brief poll. We hope that you've all had an opportunity to read the papers which Council have prepared for this arbitration, so that you will have an idea already of the subject matter and be able to express a view as to what you think the result might be. Later, after you've been subjected to the silver-tongued advocacy of Mr. Vinell and Mr. Kenny, you will be asked again to express a view. The realism of this scenario is, I think, important. Many of those watching will not have had an opportunity to see an arbitration in real life before, and we hope that this will provide an instructive event for you to take part in. I should say that this has now become very much the norm in London. What we have for you today is a semi-virtual hearing. That is to say, many of the participants, the tribunal members, and 3 of the 4 counsel will actually be present in the room, and you will see them here on the screen. One junior counsel, Anna Hoffman, will be taking part remotely, and the 2 witnesses will be taking part remotely, one from Shanghai and one from Singapore. And this is very typical of the scenario which has now developed. During the lockdown, we have also had many wholly virtual hearings, which have been conducted perfectly satisfactorily, but now many arbitrators, particularly where there is a panel of 3 arbitrators, prefer to sit together and to be able to confer where possible. But this arrangement is very flexible and can provide for most of the circumstances in the current pandemic situation. We have in London generally about 500 awards in maritime arbitration. About 100 of those cases are following an oral hearing. The other 400 are cases decided on documents only. So this is typical of one of the 100 or so cases which are heard in an oral hearing in London each year. So without further ado, I would like to introduce you to the poll, and perhaps we can put up on screen the poll which you'll be able to vote in, and we'll deal with that very briefly, and I'll hand over to Clive Aston as the chairman of the tribunal. Well, our poll seems to have not taken place, so
No, it's on our screen.
I do apologise. The poll is on your screen, and we would ask you to cast your vote in the poll.
So am I managing this poll? Edit it and share it.
So we have a result.
I think if I press end poll and share results, hopefully people can see the results.
We hope you can see the results, because unfortunately on my screen the results haven't come up. But that's simply a preliminary, and we will see whether the results of that poll will change as the arbitration proceeds. At this point, can I hand over to Clive Aston, who is the chair of the three-person tribunal in this hearing. And I hope you enjoy the proceedings.
Welcome, parties, to the hearing this morning, the hybrid hearing of arbitration between Limited and Sea Star Line SA in relation to disputes arising under a charter party dated 25th. Benefit are attending virtually. The right is Ms. Horton, Daniela Horton, arbitrator appointed on behalf of the claimant owners, and to my left, Mr. Nicholas Wu, arbitrator appointed on behalf of the respondent charterers. Just so that there is no confusion later in the hearing, I would ask those who I mentioned to raise their hand for identification so that the parties know who they are. Representing the claimant owners, we have Mr. Nicholas Vinyl, QC, and also remotely we have Ms. Anna Hoffman. For the respondent charterers, we have Mr. Julian Kenny, QC, and with him, Mr. Michael Hain. I understand that it's agreed that we have a duration of 2 hours this morning for this hearing, and so time is short, and I would urge brevity where possible. We will, I understand, be hearing evidence from 2 witnesses, one from each party, and that will be given remotely. I understand that you have between yourselves agreed a timetable for the various stages of the hearing, and I would urge you to endeavour to keep as closely to that as possible. For the benefit of the witnesses, we held a practice run yesterday, and I understand that the witnesses are familiar and happy with the practicalities of giving their evidence remotely. I don't believe there to be any housekeeping issues between the parties.
No, I don't think so, sir.
Excellent. So before we press on, let me just remind the parties to turn their mobile phones off, and if not speaking, to put their screens on mute. With that, Mr. Vinyl, let me invite you to open the case.
Thank you. Good morning, gentlemen. Good morning, madam. As you know, I appear for the owners with my learned junior, Miss Anna Hoffman, although she is remote to the room, and learned friend Mr. Julian Kenny, Queen's Counsel, and Mr. Michael Hain are for the charterers. Now, in your bundle on page 5, there is a statement of agreed facts, and it may be helpful if you turn that up. And for those watching remotely, perhaps we can have that on the screen. Let me summarize the facts. The vessel with which we're concerned is a container vessel. We're concerned with a charter party dated the 25th of March 2021 on an NYP 1946 form. Hire was at $10,000 per day, and that's a figure you'll need to bear in mind when we deal later with quantum. The charter period was 25 days plus or minus 5 days. The vessel was delivered into charter on the 1st of April 2021, and so it's common ground that the latest date for redelivery was the 30th of April 2021, giving charterers the advantage of the plus or minus 5 days. Now, although this was a short charter, two significant things happened in the course of the charter period, and it's these two things which really give rise to the disputes between the parties. The first thing is that on the 10th of April, charterers sought to nominate Porto Alegre in Brazil as the discharge port. Now, as you will have seen from the papers, the charterers were entitled to nominate up to 2 ports in the Salvador-Itajai range on the east coast of Brazil. But because they ran into difficulties, which you'll hear about in the evidence, they sought to have the vessel discharge in Porto Alegre. It's common ground that that is south of Itajai and therefore outside the range in the charter. But there's a dispute between the parties as to what was exactly said in a conversation on the telephone on the 10th of April. And some dispute, I think, also as to the effect of some emails which followed that conversation. It's common ground there was a conversation, and it took place between Miss Chen of charterers and Captain Nelson of the vessel's commercial manager on behalf of owners, and it occurred on the morning of the 10th of April. I'll come back to that dispute in a moment and explain why it matters, or at least why it might matter. The second event of interest in terms of the factual chronology is what happened just 5 days later on the 15th of April 2021. The vessel tendered notice of readiness at Porto Alegre at 7 a.m. on the 15th of April. But later that same day, there was an unexpected development. At 1900, 7 o'clock in the evening local time, the mayor of the municipality announced a COVID circuit breaker lockdown, which prohibited any work in the port and which lasted from the 16th of April to the 30th of April, a period of exactly 14 days. Now, the consequence of that lockdown, and this much is common ground, is that there was port congestion and the vessel was, as a result of the lockdown, only redelivered on the 14th of May. So that is 14 days later. Now, it might be worth looking, if we could have page 6 of the bundle, and paragraph 11. On your screens, you can see the relevant part of the explanatory notes that were given when the ordinance was made. And it says, contact tracing has revealed that a cluster of the virus circulating in our community originally entered Porto Alegre because foreign crew members infected port employees in the process of cargo operations. To safeguard members of our community, stringent testing procedures will be introduced at the port. The prohibition against port operations for a period of 14 days is an interim measure before the testing process can be rolled out at scale. So perhaps two things to note. This is not something which was directed specifically at this vessel, and its cause was something which had happened, it seems to us self-evidently, considerably before the arrival of this vessel at Porto Alegre. And I shall be inviting you to bear those factors in mind when we come to consider the issues. So what are the disputes and how do they arise? Well, the first dispute is what we've called the off-hire issue. Charterers have deducted hire for the 14-day period when the COVID circuit breaker was in place. Charterers say that the off-hire clause applies and owners say that it doesn't. Well, if we can go to page 8 of the bundle, we can see the off-hire clause. It is, I'm sure that this tribunal will be in relatively familiar form. It is not amended, a point of some significance, as we'll see later. But just for the time being, we can take it as it's written. In the event of the loss of time from, and then there's a list. Deficiency of men or stores, fire, breakdown or damages to hull, and the list goes on. And then at the end of the list, it says, or by any other cause preventing the full working of the vessel. So, in the event of loss from any of those things, the payment of hire shall cease for the time thereby lost. And it is Charterer's case, my opponent's case, that on the facts of our case, the by any other cause preventing the full working of the vessel limb is engaged. They don't say, obviously, there was deficiency of men or stores or fire, breakdown or damages to hull or anything else. They rely upon the last, what you might call catch-all provision at the end. So the issue is whether on the facts, which on this issue are agreed, trigger this limb of the off-hire clause. We say, I submit on behalf of owners, that the circuit breaker, the COVID circuit breaker, was a cause extraneous to the vessel herself, and as a matter both of authority and, I would submit, of plain common sense, is not captured by the wording in the off-hire clause, quote, any other cause preventing the full working of the vessel. We will submit that the ship was efficient in and of herself. The cause here was entirely extraneous to this particular vessel. So the off-hire clause is triggered. So that's the first issue. Issue 2 only arises if charterers are correct on issue 1, so that the vessel was off-hire. Now, in that scenario, owners say that the loss of hire they will, ex hypothesi, have suffered because of the vessel being off-hire is attributable to the fact that the vessel discharged at Porto Alegre in breach of the charter party terms. And the charterers say in response to that, no, the exchanges between the parties, which I mentioned earlier, on the 10th of April, amount to a variation of the charter party, so that there was no breach of the charter party. We say, no, that's not right, there wasn't a variation. Owners' rights were reserved, and although owners accepted the order to take the vessel to Porto Alegre, there was no variation of the charter party. Now, you'll be hearing evidence from the two individuals who were a party to the conversation, and I'm not going to preempt that because you'll be hearing from them in a moment. But perhaps if we can go to page 19 of the bundle, you will see two emails which were exchanged after the telephone conversation. At the bottom half of page 19, from Monica Chen of Charterers, and you can see first thing in the morning, 7:30, subject, MV Buena Vista to Porto Alegre. Richard, thanks for good phone conversation just now. Relieved that we found a solution. Best wishes, M. And the reply at the top of the page from Captain Nelson at 11 o'clock. Dear Monica, thank you for your call. As said, I will discuss with owners. I don't think discharging at Porto Alegre will be a problem. We'll keep you posted. So certainly, on behalf of owners, when you hear the evidence and consider the evidence of the witnesses, we will be inviting you to, at any rate, bear in mind, I'll make my submission to the end of the case, but to bear in mind what the parties committed to writing at about the same time as their conversations. So that's issue 2. Issue 3 is a disagreement as to quantum of the claim for damages for late delivery. Now, owners claim the difference between the actual, so it's a period of 14 days, that's the first thing to remember in the sums. the owners claim the difference between the actual hire, which was at $10,000 and therefore was $140,000, and the market rate. And Mr. Kenny and I agreed that the market rate at the appropriate time was $30,000 a day. It was a very strongly rising market. So owners say this is perfectly straightforward. The appropriate measure of loss is the difference between the market rate during the period of late delivery and what was payable under the charter. Charterers say, well, we accept you're entitled, owners, to damages, but they point out, and they're right as a matter of fact, that the vessel was actually delivered into a long-term 3-year charter under which the daily rate was $20,000 a day, rather than the market rate of $30,000 a day. So they say, well, your claim is limited to the difference between $20,000 and $10,000 a day, making a figure of $140,000, and that is a figure for which they give credit. So if they're right on that, there's nothing more to be done on the late delivery claim. But if we're right, there's another $140,000 to come. So unless I can help any further, those are the issues as we see them. And learned friend will also have something to say in opening, I think.
Could I just clarify one point, and that is in relation to the correspondence. The correspondence before us, is that the extent of the correspondence on this issue?
That is, and it's a perceptive question, as one would expect. But Madam, you're right. On the face of it, it looks like there might be further to come. But it's common ground that that is the limit of the correspondence that was exchanged.
Thank you.
Mr. Wu, any questions?
Not at the moment, thank you.
Thank you, Mr. Vining. Mr. Kenny.
Members of the Tribunal, I'm going to address you very briefly on the 3 issues. We accept Mr. Vining's analysis of what the issues are, but I make simply these short comments on each of them. On off-hire, as Mr. Vining rightly says, the critical question is whether, as the owners argue, this lockdown was an extraneous cause. That's the test. That's the critical puzzle. They say it was an extraneous cause, and they say in their skeleton that this is, in effect, the Errington Court all over again. You remember the Errington Court. That was a case where the Errington Court had sailed upriver on the Yangtze, and the Chinese created a barrier below Yuzu, where the ship was discharging, so that the Errington Court could not continue with her voyage and continue to trade. And they say, well, this is just the same. This is the actions of the local authorities, wholly extraneous to. What do we mean by extraneous to? We mean coming from outside and not connected with the ship. But you only have to think about what happened in the Errington Court and what happened in this case to see that that's not a right analysis. In the Errington Court, the creation of the barrier had absolutely nothing to do with the ship. What the Chinese were doing was preventing the Japanese Navy from sailing up the river. The barrier was aimed at and prompted by the Japanese Navy. Nothing to do with the Errington Court. The Chinese didn't give a fig about the Errington Court. In our case, this is a health measure which is aimed at foreign ships using the port of Porto Alegre. You ask yourself, was the Buena Vista a foreign ship using the port of Porto Alegre? Of course it was. This is a health measure designed to tackle the transmission of COVID from ships forming a class of which this ship was one. So we say in answer to the 2 points that Mr. Vinal made. His first point was, this was not a measure that was specifically aimed at this ship. It wasn't aimed specifically at this ship alone, but it was aimed at a class of ships of which this ship was one. Secondly, he says that this was a measure which was prompted by a situation which had arisen considerably before the Buena Vista arrived at Porto Alegre. True, but it was a situation which was continuing when the ship arrived, and a situation in which this ship was required to discharge. The pandemic was not over when this ship arrived. Okay, so that's all we say on off-hire. The critical question is whether it was an extraneous cause. It plainly wasn't. Secondly, the agreement to sail to Porto Alegre. I, like Mr. Vinal, am not going to anticipate what witnesses may say. This is a swearing match point, and everything depends on your evaluation of what those witnesses say. But I will make a comment on Mr. Vinal's fallback case, the Kanchenjunga argument. This is, we say, and putting it politely, an exercise in clutching at straws. There is a critical and basic distinction between what we say happened in this case, namely that parties discuss and agree to do something outside the terms of the charter that they originally made, so that in effect they amend the terms of the charter. And a case such as the Kanchenjunga, in which a party orders the ship to do something that is not permitted under the charter, and the ship complies with that, but the owners never agree that there's going to be any alteration to the terms of the charter. If the owners are going to succeed on this point, they're going to succeed on their primary case, which is that no agreement was made. If an agreement was made, that is fatal to any suggestion that it was a breach of the charter for us to send the ship to a port that the owners had only just agreed the port could go, the ship could go to. Okay, and then issue 3, measure of damages. Attractively and ingeniously, as this point will no doubt be put by Ms. Hoffman, this is a point which calls for the application of the most basic principle of English damages law. And I only have to remind you of a quote which appears in almost the first paragraph of every textbook on the subject of damages. That is Baron Park's comment in Robinson and Harman. The rule of the common law is that where a party sustains a loss by reason of a breach of contract, he is, so far as money can do it, to be placed in the same situation with respect to damages as if the contract had been performed. You only have to ask yourself one question. What position would these owners have been in if this contract had been performed and the ship had been returned on time? The answer is the ship would have been put straight into her long-term fixture and she would have earned $20,000 a day for the relevant 14 days. That is the end of that point. Those are our comments in opening. We'll expand each of those points in closing, but we have nothing more to say at this stage.
Any questions? Any questions? Not at this time. Thank you, Mr. Kenny. Mr. Vinal, your evidence.
Yes, so I would like to call Mr. Nelson, please, who can appear on our screen.
Hello.
Good morning, Captain Nelson.
Good morning.
I hope you can hear us and see us clearly.
Yes, I can. Thank you very much.
Excellent. At the beginning of the hearing, I hope you saw when I pointed out who the various people you're seeing on your screen are and who they represent.
Yes, and I have their names below their faces, so I can see this. Thank you very much.
Now, we'd usually at this time ask the witness to show us that nobody else is in the room and that they don't have any notes that we're not aware of. but I understand that counsel for both parties have satisfied themselves that this is not the case here, and that there are no aides or anything else in the room with you.
Yes, and from my behalf, I can say that that is also true. It's true.
Thank you very much. Now, you will now probably have a few short questions from Mr. Vinal. That will then be followed by probably rather more questions from Mr. Kenny, with Mr. Vinal having the right to make any further questions after that, if any matters arise out of the cross-examination. Now, we don't nowadays ask witnesses to swear an oath as to the evidence that they're giving, but we do expect them to confirm that the evidence that they're going to give to us is truthful. And I'd ask simply that you confirm that what you say to us today will indeed be the truth.
I can confirm that.
Thank you. Mr. Vinal.
Good. So, Captain Nelson, you can hear me and see me okay, can you?
Yes, I can. Thank you.
Do you have access to the bundle of documents? And if so, could that be open, please, at page 15?
Yes, I have it open on the page.
Great. Now, if we look at paragraph 2 of that statement, I think a gremlin's crept in because you were not, in fact, the master of the vessel, were you?
No, that's correct. So I am a qualified master mariner, but there seems to be an editing issue. I was not actually the master in charge of the ship at the time.
Yes. And subject to that amendment, can you confirm to the tribunal that the statements made in your witness statement are true, and you wish to adopt that as your evidence in chief?
Yes, please. And could I also adopt on point 4 that I didn't oversee the physical loading of the cargo, but I did receive emails to my office with the charter's loading plan, for example.
I understand. Well, Mr. Kenny, I don't think anything turns on this. Mr. Kenny will ask you if so minded.
Okay.
So he will now, I've nothing further for you, and so Mr. Kenny will ask you some questions.
Okay.
Captain Nelson, you are a commercial manager at Duxton Hill, is that right?
That is correct, yes.
Where are your offices?
On Duxton Hill. The office is named after the hill that it's on.
That's in Singapore, is it?
Yes, correct.
And do I understand that you were, in March and April of this year, in charge of arranging the employment for this ship?
Yes, that's correct.
So you negotiate and charter ships on behalf of her owner's good ship?
Yes, on a regular basis. That's my daily function at the office.
You're employed to decide how this ship will be traded, aren't you?
That's correct. Yeah.
Sorry, I interrupted you. You were going to say something more?
Well, I also have to liaise with my owners. So I bring the commercial terms, but the owners will also decide on the suitability for the trade, or if it's a trade that they wish to do.
Okay, so if a charterer wants to charter the Buena Vista, he or she would have to come to you?
That's correct. So a charterer or a charterer's broker would speak to me.
And if a charterer wanted to agree some change to the terms of a charter, he or she would have to contact you, wouldn't she?
That's correct. Yeah.
And can I just ask you? You said you have to refer back to your owners. Who is your contact at Good Ship Limited?
Well, I have a number of managers, bosses. I mean, do you want to know a specific name, or
do you have one contact, or do you speak to the management team generally?
I speak to the management team generally, but there is a Mr. Ricky that I speak to on a regular basis.
Okay, and just so we understand the terms of what you do and what you refer back, what do you have to speak to Ricky or the management team about?
Well, there's a number of things that I might have to talk to them about. There's the physical operations of the ship. So owners, the charterers will communicate with me on a daily basis regarding the ships, finding agents, for example, in the ship, in the ports that they're going to, or if there is sludge that needs to be removed, invoices, all the daily function that would go on throughout a charter.
Okay, but am I right to say that the good ship follow your advice as to what is appropriate employment for this ship?
They certainly take that. Yeah, they take what I say as, into advisory, certainly. Yeah.
Okay. Now, this charter was concluded on the 25th of March of this year.
That's correct. Yes.
And you negotiated the fixture.
Yes.
And you fixed it with Monica Chen, didn't you?
That's correct. Yes.
And I think you said earlier you've dealt with her on a number of previous occasions.
Yes, I mean, I speak to a number of different charterers in the market who have requirements. That's part of my function, to go out and find employment for the ship. So Miss Chen is someone who I have spoken to numerous times over the years.
So in your mind, you take the view that if Miss Chen needed to amend the terms of this charter or change the terms of this charter, she should and would come to you.
I would certainly be the first port of call, that's right.
Okay, can I ask you now about the what you were doing in early April? If we look at your statement,
Right.
which we have at page 15 of the bundle, you say, paragraph 2, you say, I was the master of the Buena Vista at the relevant time. I've been a master engaged on similar vessels for 20 years. I think Mr. Vinyl described this as a gremlin, and I think you said it was an editing problem. Can I just ask you, did you write this statement, or did someone else write it for you?
I wrote it, but I believe that I made the mistake. What I was trying to qualify was that I am a master, but I am now I'm a qualified master mariner, but I am now fully land-based. I've retired from the sea, and I just meant that I'm the master, but not the master of the ship itself.
I mean, can you explain how you came to misstate the position in this, in the way that we see here in paragraph 2?
No, I can't really explain it, but it is such an obvious mistake in my mind. I mean, I wasn't physically on the ship, so it's just clearly an error as far as I can see.
Okay, I'm afraid I have to ask you this. Were you trying to give this tribunal the impression that you were just a seaman and you weren't responsible for agreeing the terms of the charter?
No, that was not my intention at all.
Okay, can I ask you now about the call that you had with Miss Chen on the 10th of April? Do you remember where you were when you had that call?
Yeah, I was at home.
What, in Singapore?
Yes, correct.
Do you remember what time it was when she called you?
No, I mean, it was sometime in the morning, early, I believe.
Do you remember what you were doing at the time?
I was at home. I think I had taken the dogs for a walk quite early in the morning.
Okay, can we look at paragraph 6 of your statement? You say there that Ms. Chen told you that there were construction issues at the destination port. Do you remember what port she said it was?
I don't. I don't remember which. Was it Rio? I think that she said that Rio had construction issues.
Okay. And were you aware at the time that you had this call that the ship was still several days sailing away from either Rio or Porto Alegre?
Not really. Although my primary function is to arrange the commercial terms, but at some point I then relinquish the responsibility over to the management of the ship. So I have in the back of my mind I know roughly when the ship will be coming back or is available for its next charter. I'm focused on finding the next employment, but exactly where in the sea it is or what location it is at any time, I'm not always fully aware.
Okay, you say in your statement that Miss Chen told you there was a potential solution.
Yes.
And asked whether we could discharge instead at Porto Alegre.
Yes.
Is this right? As you understood it, Miss Chen had not yet decided that the ship would go to Porto Alegre. She was merely exploring possibilities.
No, I think she had a very, I think she was specifically asking me whether the ship could actually go to that port.
Yes, but she wasn't giving you an order to go there, was she?
No, she was asking permission to go there.
And you said that, in your view, she could, and you were prepared to agree that.
Well, yes, exactly. So in my mind, I knew that the vessel couldn't, under the rules of the charter party, go to that particular port as it was outside of the trading range. So there were two things in my mind. The first one was that when a charterer wishes to trade outside of the trading range, you have a unique commercial opportunity. You can say, okay, we can allow you to do this, but we want to increase the charter rate, for example. So in the back of my mind, I felt that there was an opportunity, but also you want to be friendly to your charterers. You want to be as amenable as possible. And there was no physical reason why the ship couldn't go other than it wasn't in the charter party. The ship's draft was suitable for the port. I mean, there was no sort of solid reason why it couldn't. So I said to her that I would have a word with my management team and get back to her.
Okay, but what you didn't say was, as you have it at paragraph 7, which I think is now on your screen,
yeah,
that you most certainly reserved all of owner's rights. That's not something you said, was it?
Well, I think I did say that, in so much as, quite often in these conversations, I've been doing this for a long time, you say without prejudice to the CP or without, I certainly implied that there was no reason why the ship couldn't go, but I needed to check with the owners.
Okay, and following that call, you sent the email that we see at page 19 of the bundle.
Sorry, I'm just finding it. Yeah. Yes, I've got it in front of me.
Can I ask you this? Are you quite sure that you said to Ms. Chen that you needed to speak to the owners in the call, or was that an afterthought? Something you first thought to say when you sent this email?
I'm fairly sure. I wouldn't. It's not. It would be very strange for me to ever agree something completely outright without first checking with my owners. It's not common practice for me to do that. It's not really my decision to make. So I always try to avoid making a commitment. It allows me to think about how best to approach her. And like I said, I mean, charging a higher rate to go outside of the trading range was a real possibility. It's opportunistic, I know, but it's something that, we have to do as owners.
Okay, and so am I right to say that you did then speak to the owners and they just approved it?
Well, again, it was something that I had spoken to them on, it was Sunday, so it wasn't the working day. Although she was under pressure, I certainly spoke to a few, I mean, Mr. Ricky, for example. There was no, he was potentially okay with it. There was no reason why the ship couldn't do it.
Okay. So you spoke to them. The ship did, in fact, then proceed to Porto Alegre. The owners must have said that it was okay, right?
Well, as far as I'm aware, there's been no communication with the charterers saying that it's okay. The confusion, I think, really lies in the fact that the vessel sailed in the direction of Porto Alegre. So the master had been instructed, and who allowed that instruction to go forward, I don't know, but that is part of my management team.
So what we know is the master was instructed to go to Porto Alegre. He went. The owners must have approved it, right?
No,
if the owners hadn't approved it, the ship wouldn't have gone there.
Well, that is something that my owners need to talk to their master about. I think that there was a breakdown in communication. I think there was just why the master took that upon himself to trade outside of the trading range without discussing with us is something that, the management needs to discuss with the master.
I'll ask you the question one more time. You don't know that it's not your evidence that the owners ever rejected the idea of going to Porto Alegre?
No, there was no, we didn't say, no, you cannot go. We simply said, we'll get back to you on it. Yeah.
So the position really is that on your evidence, you had told Miss Chen that you'd need to get the owner's approval, and you subsequently accepted an order to go to the port. So she rightly understood that you had got that approval.
I don't know how she would have got that impression. I mean, like I said, in the back of my mind, I was looking forward to going back to her and saying, look, I'm sorry, Miss Chen, but it's outside of the trading range, but we can extend this for you if you pay us an extra $5,000 a day or whatever it is.
Okay. Well, no further questions.
Thanks.
And I have no re-examination. Thank you.
Any questions? There are no questions from the tribunal, Captain Nelson. Thank you. That therefore concludes your evidence. Thank you for participating in this reference. And we're happy now to release you from this arbitration.
Thank you very much.
I don't think you have any other evidence to introduce.
No, that's my only witness.
Okay, so
I'm going to call my witness, Miss Chen, then. Miss Chen, good morning or
Morning.
good afternoon
Morning.
where you are.
Thank you.
Good evening, Ms. Chen, and thank you for joining us in this arbitration. As I've mentioned to the other witness in this case, we understand that there is nobody else in the room with you and that you don't have any aids to giving your evidence to us this morning. Is that correct?
Yes.
Okay. Although you may have heard that on occasion witnesses are required to swear an oath of truth of their evidence, that isn't the general practice in London arbitration. We do, however, expect you to tell the truth when giving your evidence. So perhaps you would kindly confirm to us that the evidence you give to us this morning will be truthful.
Yes, I confirm. Thank you.
Thank you. Mr. Kenny.
Ms. Chen, you've made a witness statement, which we see at page 17 of the bundle,
Yes,
and you've signed it at page 18.
yes, it's my signature.
Are you content that this should be your evidence in this arbitration?
Yes.
Okay, Ms. Chen, I just have 3 questions for you. First of all, this. In his evidence, Captain Nelson said that he agreed to go to Porto Alegre, but he needed to speak to his owners about it. What do you say about that?
I think during the telephone call, Captain Nelson is very confirmative that he agreed the vessel could go to that port. And he did not reserve any rights, but he told me that he will discuss with the owner. And I didn't hear anything further from him. So to my point of view, I think there's no objection from the owner.
Okay. If Captain Nelson had said that, in response to you saying that you wanted to go to Porto Alegre, if he'd said that that was not in line with the charter and he reserved owners' rights, how would you have reacted to that?
I think I will then further negotiate with him to get his approval, or if he reserves his rights, I will wait for the final conclusion about this point to see if there's anything further we can do. But there's nothing.
Okay. And finally, we've seen at page 19 this email exchange. What further communications did you have with the owners about the vessels going to Porto Alegre?
Nothing. So I think there's no objection from the owner, just agreed by Captain Nelson.
I've got no further questions. Ms. Chen, if you wait there, Mr. Vinal will have some questions for you.
Okay, thank you.
Ms. Chen, how many times have you spoken to Captain Nelson? Do you frequently speak to him?
Yes, quite a lot. Because we negotiate the charter party with Captain Nelson, so there's some negotiation on the terms of the charter party, and after that, we also have daily communication if necessary.
And when you negotiated the terms of the charter party, did you have recaps going to and fro between you?
Yeah.
By email?
Sometimes by phone call, because it's more convenient.
But you would always confirm the terms of the charter party in writing, wouldn't you?
So when we draft and signed the charter party, yes, we did it in writing. But after that, for some daily communication, we just did it on telephone call.
And the reason why you would confirm the terms of a charter party in writing, apart from anything else, is that it avoids arguments over what the terms of the charter party are. Is that right?
I think that depends, because actually this is a common practice that there should be a fixture between the parties. But when we, regarding the daily running of the vessel, sometimes it's more like flexible and we just communicate via phone call.
Yes. So for day-to-day issues arising in the course of the charter party, you might be relatively informal, but in relation to the terms of the charter party, you would expect a degree of formality. Do you accept that?
Sorry, I think it still depends. To my point of view, there is no a very like fixed understanding about what kind of thing should be terms. After we sign the charter party, then it's more convenient to discuss the problem via phone call. especially in this quick move world. Things could make very quickly, so sometimes it's just grab a phone call and discuss and confirm.
And what records do you have of your conversation with Captain Nelson?
Could you clarify when you may record? Do you prefer a written record or just recollection from my mind?
Yes. Do you have any written or electronic record, or are you entirely dependent on your recollection?
So some is from my recollection and also the email as you see in the bundle.
So did you have the emails available to you when you produced your witness statement? I think you must have done.
Yes, yes, of course.
And so you felt you needed the emails, did you, to refresh your recollection of what had been said in the conversation?
Not really. I use that email as an evidence trying to show that actually it's confirmed by Captain Nelson that the vessel could go to that port. So it's more like my supporting document to prove what I said in my witness statement.
Now, in your witness statement, you don't purport, you don't set out the precise words that passed between you and Captain Nelson. Why have you not set out the precise words that were used in the telephone conversation?
Because I know this is an arbitration, I should be very prudent and careful. I cannot recite what I said during the telephone call, so I do not use those precise words. But actually, that telephone call is very quick, and the issue we discuss is very straightforward. So the main issue is just I ask whether the vessel could go to that alternative port, and Captain Nelson just agreed.
Okay, so let's collect where we've got to so far. The telephone call was a quick call, correct?
Yes.
And you can't remember the precise words used in it, correct?
That not really say so. It's not that I cannot precisely remember what I said. I only cannot very confirm for each word.
Yes,
so because
you can't recall
it's the oral communication, but I can 100% very confirm what we discussed and agreed about that telephone call.
Well, I think you're agreeing with me that you cannot recall the precise words used in the conversation.
Sometimes there's very flexible greetings, and for those kind of greetings, I cannot recall.
So can we just set the scene against which this conversation took place? You had a problem because the vessel, which was already en route to Rio, could not discharge at Rio. Is that right?
Yes.
And I don't know whose fault that was, but it was your responsibility to resolve it. Is that correct?
Yes, because I'm the regional head.
So you had a problem?
Yes.
And the only solution you could think of was for the vessel to go to Porto Alegre. Is that right?
Not really, because I just want to discuss with Captain Nelson to see if he would agree. So if he agreed, then problem solved. But if there is any objection, then we will do further renegotiation, or even we can wait for a while to find a better alternative. But it's very pleased to me that Captain Nelson just agreed. So problem solved.
Well, I just wanted to focus on the position before the telephone call. You had in mind a potential solution, which was that the vessel go to Porto Alegre. there was no other solution on the table as far as you were concerned, was there?
No. So if I think Captain Nelson cannot agree, then we can further discuss. And we may wait for a while to see the construction work will finish, because we still have some days before the deadline.
Well, it's pretty tight,
I
isn't
think
it? We're already on the morning of the 10th of April.
we still have 20 days.
So you have the conversation and you tell us in your witness statement that Captain Nelson was not best pleased about the change. That wasn't put to Captain Nelson, but can you explain to us what you mean by that?
So obviously, when I discussed this problem with him, he hesitated for a moment, but then he just confirmed that it will be work, so the vessel could go to that port. So after a very slight hesitation, Captain Nelson confirmed.
Now, I want to suggest to you that Captain Nelson did not confirm in the conversation, and that in fact he indicated that although he thought it might not be a problem, he would discuss with owners and keep you posted. Isn't that actually what he said?
Not really. I think what he said is that it should not be a problem and the vessel could go to that port. But to be safe, he will tell the owner and let me know if there is an objection also.
Well, let's look at the emails on page 19 of the bundle, please.
Yes, please.
The first is from you. You say, thanks for the good phone conversation just now, relieved that we found a solution. And you were relieved, weren't you? Because you thought that you probably had found a solution to your problem. Correct?
I was very much relieved because Captain Nelson just agreed and very confirmatively agreed during the concord that the vessel could go to that port.
Okay, well, I've already suggested to you that's not what was said. Let's look at his response at 11 o'clock. Dear Monica, you did receive this response, did you? The upper email?
Yes.
Dear Monica, thank you for your call. As said, I will discuss with owners. I don't think discharging at Porto Alegre will be a problem. We'll keep you posted. Now that's inconsistent, isn't it, with an agreement having been made in the earlier conversation?
I think that message is slightly different from what we discussed in Concord during the phone call, because during the phone call, the first said by Captain Nelson is a very confirmative agreed that the vessel could go to that port. But by the end of the conversation, Captain Nelson told me that to be safe, he will also inform the owners about this change, because at least when the vessel go to that port, the owner should know. Otherwise, there was some problem between the master and the owner's communication. So he told me that he will tell the owners anyway.
Well, Ms. Chen, you told the tribunal that you think Mr. Captain Nelson's email is not quite consistent with your recollection of the phone call. And if that's right, why didn't you respond to him to clear things up?
Because I don't see that as a problem. As you see that the vessel is en route, and if we go to the alternative port, it will only take like 10 or 15 hours. So I think if there's any objection from the owners, then Captain Nelson will let me know in a very quick movement, but there's no such kind of communication. So I think this just reconfirmed or enhanced my understanding that there's no problem as agreed during the telephone call.
The truth is you didn't want to press the position, did you?
I cannot say that, because as a regional head, I should be very prudent and I should always represent the interest of my company. So if I see a problem, I will fix it. But the question is that I don't see there's any problem regarding the agreement made by Captain Nelson. So there's no need to further clarify.
Well, the vagueness helps your commercial interest, doesn't it? Because as long as the vessel does go to Porto Alegre, your problems are solved, correct?
First, I confirm that if the vessel could go to Port Alegre, then it will there will no problem. But because I see there is an agreement, so I quite confirmed that this is agreed by Captain Nelson. I know that if there's no agreement, there we will be like some dispute under the charter party, and I will not allow that happen. I do not put that risk on my company, because I know how things could be disputable in the shipping world.
But there's also a problem that if you press owners for a formal amendment of the charter party, they might ask for increased hire. So there's nothing in it for you to go back to them and press for something formal, is there?
I think I know that if the party do not agree, then we will have further negotiation, and there is a possibility that the hire should be renegotiated. But for me, it's very clear that first, Captain Nelson agreed in telephone concord, and more importantly, the vessel just went to that port.
Final question, you didn't expect the ordinance to be made, did you? The ordinance which caused the vessel to be delayed at Porto Alegre?
I think it's hardly say so, because you know that in the COVID-19, everything could move very fast. And we have saw a lot of cases that a sudden breakout just happened in a local port. So when we try to find alternative port, I do have a concern that any uncertainty may happen. So it cannot say that I do not expect that an order may made. On contrast, I think like in this COVID-19 background, everything could happen. And I think that like the original port, if the vessel all go to that port, then there may be a breakout in that port.
Thank you very much. Ms. Chen, I don't have any further questions for you.
Thank you.
No re-examination, thank you.
Thank you.
Do you have any questions? No. Just a couple of questions from me, Mr. Chen. Presumably at some point you gave instructions to the vessel to proceed to Porto Alegre by email.
Sorry, could you?
Let me repeat. Presumably at some point you gave instructions to the master to proceed to Porto Alegre.
Actually, the communication is not made by me with the master. So I'm not very sure the communication with the master. I'm the regional head, so I'm more like on a higher level of communication. That's why I only contact the commercial manager, who is the Captain Nelson.
Right, right. So you don't know whether, if written instructions were sent, they were copied to Captain Nelson?
I don't know, because it's a daily management, and my colleagues who is like lower level of the company will deal with it.
Right. Okay, thank you very much. I don't have any further questions. So it remains for me only to thank you for giving evidence and joining us in this arbitration, and to now formally release you from giving evidence in the arbitration hearing. Thank you very much indeed.
Thank you.
So now that that completes the evidence, Mr. Vinal.
Yes, straight on to closing.
Indeed. How are we doing for time? I think we're on schedule.
No rest for the wicked, and I think we're probably on track because, given the evidence, I think I can close the matter very briefly indeed. I'm going to take the first two issues, and Ms. Hoffman is going to take the third. The first issue is the off-hire clause. The issue, obviously, as I opened, was the vessel off hire. And I just want to begin with the announcement and go back to that on page 6 of the bundle, because it seems to us that the terms of the announcement are both revealing and important. And you can be certain that we say, and you should find as a fact, that there was, by the 15th of April, a cluster of COVID cases in Porto Alegre, that contact tracing had already occurred, and contact tracing had shown that the virus originally entered Porto Alegre through infected port employees because of foreign crew members. And I just want to emphasize that point, because what flows from it is that the decision by the mayor to announce a circuit breaker has absolutely nothing to do with our vessel. It would have been made whether or not our vessel was in Rio or Porto Alegre or on the moon. It would make not one iota of difference to what happened in the port. And it flows from that the decision had nothing to do with the condition of our vessel. Nothing to do with our vessel at all. For sure, it affected our vessel. That's right. It affected it, but it wasn't in any sense driven by it or caused by it. So once we've got that clear, we ought to look at what the law says about test. As I'm sure the tribunal will know, there's quite a lot of authorities on off-hire, but because of the time constraints, I'm not going to take you through all of them. I'm not even going to take you to all of the ones we've got in our bundle, but I am going to ask you to turn to the Laconian Confidence, which starts in the bundle at page 28, and it's a decision from 1997 of Mr. Justice Riggs, as he then was. If we had longer, I would take you through his treatment of the authorities, which is revealing and useful. But for the time being, just two parts of the judgment. First, at page 28, if you look in the headnote in the left-hand column, you will see a clause that, just like ours set out, but without the words any cause whatsoever, without that wording. And you'll see the facts: the charterer shipped a cargo of 10,000 tons of bagged rice in New Sound jute bags. The vessel sailed to Chittagong, discharged her party, but a joint survey established the presence remaining on board of 16 tons of rejected residue sweepings. And the Bangladesh port authorities refused to allow the Laconian Confidence to proceed to her next business because of the presence remaining on board of the residue sweepings. So pausing there, it's an authority interference case, but actually, quite unlike our case, and you might think on rather stronger facts for charterers, it's a case where there was authority interference because of something to do with the state of the vessel. Now, Mr. Justice Ricks considered the authorities carefully, and he decided that this vessel was not off. But it's what he says about the law which is transferable to our case. And can we go to page 150, please?
Is that page 39 of the bundle?
It is. I beg your pardon. It is page 39 of the bundle. Thank you. And we could pick it up in the right-hand column, beginning in my judgment, therefore. He says, in my judgment, the qualifying phrase preventing the full working of the vessel doesn't require the vessel to be inefficient in herself. A vessel's working may be prevented by legal as well as physical means, and by outside as well as internal causes. An otherwise totally efficient ship may be prevented from working. That's the natural meaning of those words. Okay, well that, so far, if that's all you read, you might think that helps charterers. But he goes on. The question remains, of course, whether a ship has been prevented from working by a cause within the clause. Moreover, he says it will generally be relevant to find whether the ship is efficient in herself, either because it may be relevant to point out that the vessel's working had not been prevented, or because, in considering whether an alleged cause of off-hire is a cause within the clause, it may be very pertinent to point out that the vessel was otherwise efficient in herself. Pausing there, our vessel was undoubtedly perfectly efficient in and of herself. And he says, those comments bring me back to consider the phrase any other cause in the light of the authorities. In my judgment, it's well established that those words, in the absence of whatsoever, just a little bit lower on the page, I think, that we've got on screen, bottom right-hand corner of that page. And he says, a consideration of the named causes indicates that they all relate to the physical condition or efficiency of either vessel, including its crew, or in one instance, cargo. There is, moreover, the general context that it is for, and we're over the page now, top left-hand corner, for the owners to provide an efficient ship and crew. In such circumstances, it's to my mind natural to conclude that the unamended words do not cover an entirely extraneous cause like the boom in court line, or the interference of authorities unjustified by the condition of ship or cargo. So that, it seems to us, is the test. Learned friend teases me and says this case is not quite like the boom in the court line case, and it's not quite like the boom in the court line case. I accept that. This is an interference of authorities. But the critical point is, and the way you can test the answer to this question, is what would have happened even if this vessel hadn't been here at all? And the answer is the ordinance would have been made. So the ordinance is made for a cause entirely extraneous to our particular vessel. And so the vessel was not off hire, and so the second issue does not arise. But if the second issue were to arise, we submit that the burden is on charterers to demonstrate a variation of the charter party. And that is a burden which they have not come close to discharge. It must, we would submit, be obvious from both of the witnesses that neither of them can remember exactly what words were used in their early morning telephone conversation. You should not be surprised by that, and you should not hold it against them, because honest witnesses generally can't remember the precise words they use. And in those circumstances, your safest course is to look at what passed contemporaneously between the parties. That is the emails on page 19 of the bundle. And that surely, we would say, supports Mr. Nelson's account. and is quite inconsistent with a settled agreement to vary the terms of the Charter Party. The truth is, the precise sequence of events which caused the master, in fact, to go to Porto Alegre are shrouded in a certain amount of mystery in this case. And you have not heard satisfactory or complete evidence from either party about it. But what you have heard and what you can see is that these emails record a conversation which falls well short of a formal variation to the Charter Party. Page 19 of the bundle, the upper email. Dear Monica, thank you for your call. As said, I will discuss with owners. I don't think discharging at Porto Alegre will be a problem. We'll keep you posted. Now, if Miss Chen had thought that didn't properly reflect what had been said, she'd have responded, surely. She didn't need to, because she was hoping that all that she needed and wanted, which was that the vessel actually went to Porto Alegre, would happen. She wasn't bothered about formal variations. She was bothered about solving her commercial problem. And that's why things were left open. Well short of the variation. So that's all I wanted to say on issues 1 and 2. And Ms. Hoffman will deal briefly with the quantum issue.
Good morning. Thank you. I hope you can all hear me.
Yes.
Thank you. I will spend the next 5 minutes or so very briefly dealing with the redelivery quantum point, which is set out as the third issue in owner's skeleton argument, which can be found on page 122 of the bundle. That's just for your notes, no need to bring it up. It is, as you've heard, common ground that the vessel was delivered 14 days late. And the question really for you today is whether owners are entitled to the market rate or rather only the follow-on charter rate. There's a difference of $10,000 per day. Now, why should owners be entitled to the market rate? It is really a very simple argument we're presenting here today. It proceeds in 3 simple steps. Firstly, they're entitled to this rate because that is the normal measure of damages. And secondly, there's no reason to depart from this normal measure of damages in this case. And thirdly, the authorities my learned friend wishes to rely on and has foreshadowed in the skeleton argument that the golden victory can and should be distinguished. Now, it will be unsurprising to you that we rely on the market rate as being the normal measure of damages. This is, of course, an entirely uncontroversial proposition, I would have thought. And I just wanted, in the interest of time, draw your attention to one passage that makes this point quite clearly. If you could please turn up page 90 of the bundle. This is from the very well-known case, the Achilles, and this is from the judgment of Lord Hoffman. If we could please zoom in on paragraph 6. This is Lord Hoffman citing the arbitrator, the minority arbitrator, with whose views, of course, the court eventually agreed. And towards the end of that paragraph, he states, but he, that is the arbitrator, said that a reasonable man in the position of the charterers would not have understood that he was assuming liability for the risk of the type of loss in question, which in this case was the follow-on charter rate. The general understanding in the shipping market was that liability was restricted to the difference between the market rate and the charter rate for the overrun period, and any departure from this rule is likely to give rise to a real risk of serious commercial uncertainty, which the industry as a whole would regard as undesirable. And of course, you'll be entirely familiar with the Achilles. But the main point that I wish to draw to your attention here is that it is indeed the normal measure of damages to look at the market rate. And that the crucial question to ask is, what kind of loss did the parties have in mind? What did they contemplate when they made the agreement, when they made the contract? And in a curious twist, in this case, the parties are arguing the inverse of the Achilles. Owners wish to rely on the normal measure, the market rate, and charters wish to say that the follow-on charter should apply. However, the general principle of the Achilles, that the market rate applies, should be followed here. Sometimes that will favor the charters, sometimes it will favor the owners. but the general principle should not be deviated from, also for these commercial reasons that you've just heard about. Now, it is of course right that sometimes this principle can be deviated from, and this is where the golden victory comes in, and undoubtedly you will have seen in the skeleton argument from my learned friend that he wishes to rely on the golden victory. Now, there are 4 short points on that authority. The first important point is the lordships did not disagree and indeed affirmed the general principle that usually the market rate was the appropriate measure of damages. For example, Lord Bingham makes that point in paragraph 10, just for your note, we don't have time to go to that at the moment. Then they do comment that in some cases, exceptional cases, the facts as they took place after the breach of contract can be taken into account. And they mention a variety of cases, and all of them share one feature. All of them are exceptional. They involve, such as the golden victory itself, extreme situations such as war breaking out, or an absence of a market. No market can be found. And that is when they say other events can be taken into account. Thirdly, these other events that can be taken into account to deviate from the usual measure of damages are all described to occur with a high degree of certainty. They're described, as Lord Scott puts it at paragraph 30, as predestined, and an event that is predictable with total confidence, for example, at paragraph 40. Now, in this case, the redelivery into the follow-on charter at the very beginning of that follow-on charter was not predestined. It was not inevitable. Owners had the right to redeliver, or to rather deliver, into the next charter between the 1st and the 20th of May. Yes, there may have been an intention to deliver the vessel early into that follow-on charter, but they also had the right, they didn't sign away that right, crucially, to trade the ship during the 1st and the 14th of May. They had the right to do so. And that is the right that they lost. And for that loss, we say they should be compensated at the usual rate. And this is a normal case. This is not an exceptional case. And hence the normal principle, as endorsed in the Achilles, which obviously also postdates the golden victory, should be applied. Unless I can assist you any further on this, these are owner submissions on the 3rd issue.
Thank you. Thank you very much, Ms. Hoffman. Do you have any questions arising out of that? Thank you very much. I believe that completes your closing, and therefore it's time for Mr. Kenny.
Yes.
Your closing submissions, please.
In the same way that Mr. Vinyl did, I'm going to address you on the first 2 points and leave the 3rd point, which is perhaps the point of real intellectual difficulty, to be dealt with by Mr. Haynes. Off-hire. To decide this issue, you'll have to ask yourself 2 questions. First question, what's the relevant test? What do charterers have to prove to bring themselves within clause 15? Second question, on the facts of this case, is that test satisfied? All right, let's look at the test first of all. As Mr. Vinyl did, I'm going to start with the Laconian confidence. And he has already reminded you that that was a case in which, like the present case, parties had agreed an unamended clause 15, in other words, whatsoever had not been added. And the local authorities then made an order which prevented the ship from trading for a number of weeks. From that decision, one can draw 2 relevant principles. The first is, where a ship is prevented from discharging by the authorities, her full working is prevented, even if the ship is not suffering from any internal problems. Okay, and you find that principle at page 39 of the bundle, which is page 150 of the report, column 2. And I just ask you to put your pen against the passage that begins in the middle of the page. In my judgment, therefore, the qualifying phrase, preventing the full working of the vessel, does not require the vessel to be inefficient in herself. A vessel's working may be prevented by legal as well as physical means, and by outside as well as internal causes. And that principle is helpfully illustrated by Mr. Justice Makata's decision in the Apollo. And we can pick up the references to that in the Laconian Confidence Report. First of all, at page 30 of the Laconian Confidence, that's page 30 of the bundle, page 141, column 1. And I just ask you to look at the bottom of that column where it says, in the Apollo, the vessel was denied free pratique and thus prevented from berthing and discharging while the suspicion of typhus in 2 of her crew members was investigated, and as it turned out, eliminated. And then you can see how that fits into the principle we've identified at page 148, column 1, page 37 of our bundle. And again, I just ask you to pick up in the first column. Similarly, I don't think the Apollo supports the judicial gloss. We don't need to worry about what that judicial gloss is. It was the idea that there had to be some internal inefficiency on the ship. On the contrary, Mr. Justice Makata said, in my judgment, the action taken by the port health authorities did prevent the full working of the vessel, did bring the off-hire clause into play. It seems to me that in saying this, Mr. Justice Makata was recognising that a vessel could be prevented from working by an outside bar on her working. Okay, so that's the first principle, a legal obstacle to performing the charter service is sufficient. Second principle, we put it this way. Where the full working of the vessel has been prevented by the local authorities, that will be an event that comes within the phrase, any other cause preventing the working of the vessel, if the local authority is acting properly and reasonably in response to the suspected presence of a serious disease or health hazard on the chartered ship. So, we're within any other cause preventing working the vessel if the local authority is acting properly and reasonably in response to the suspected presence of a disease or health hazard on the chartered ship. All right, now, where does one get that from? You get it from, if we look at page 40 of the report, sorry, that's 40 of the bundle, page 151 of the Lloyd's numbering, at column 2. And I ask you to pick up in the 4th paragraph in column 2, where the judge says this. The authorities suggest, moreover, that where the authorities act properly or reasonably pursuant to the brackets suspected inefficiency or incapacity of the vessel, any time lost may well be off hire even in the absence of the word whatsoever. And he refers to the Apollo and says, Mr. Justice Makata stressed that there was good cause for the careful testing and disinfection that was carried out. And Lord Justice Griffiths said in the Aquacharm that no responsible person would use a ship suspected of carrying typhus. And And he then goes on at the end of the paragraph to refer to a similar case, not a health hazard in that case, that's the Bridgestone Maru, where again there was a suspicion of some deficiency in the vessel and the authorities acted properly and reasonably. Now, I emphasize the authorities must be acting properly and reasonably because that was the critical factor in the Laconian confidence itself. The reason the ship was not off hire was because the authorities were not acting properly and reasonably. They were acting capriciously. And what the judge found in the Laconian confidence was that the actions of the authorities couldn't, in law, be said to have been caused by the presence of cargo residues on the ship, because no reasonable authority faced with those cargo residues could have acted as this authority did. And you find that point succinctly stated at the top of this column 2, where what the judge says is, I'd be extremely doubtful in any event that a capricious suspicion could bring their action, as the action of the authority, within the clause. Okay, so those are the two principles that we say make up the test. One, was the vessel prevented from discharging by the local authorities? And two, was the local authority acting reasonably and properly in response to a reasonable suspicion of serious disease or health hazard on board this ship? And then we'll come to answer that question on the facts of the case. And there's really no argument about the first test. It's absolutely indisputable that the vessel was prevented from discharging by the lockdown. The real focus of the dispute is on the second test. Was the local authority acting reasonably and properly in response to a reasonable suspicion there was a serious disease or health hazard on this? And one can see that by reference, by looking at paragraph 11 of the agreed facts, which is at page 6 of the bundle. And the explanatory notes, which tell you what the authority were doing. And we say this, that these are the inferences to be, these are the points to be understood from that. First of all, there was a reasonable suspicion, because there had in fact been cases of transmission, that foreign ships using the port as a class had been and were transmitting COVID. And that was a reasonable suspicion because contact tracing had established that fact. Now, I just say as an aside, the fact that the local authority were acting on the basis that a class of users of the port presented a risk of transmission doesn't make their actions in any way unreasonable. You don't have to have evidence that a particular traveller from Montenegro is carrying the Delta variant. If you're the British government, what you do is say all travellers, regardless of what the evidence about their individual case may be, have to quarantine or have to go through steps A, B, and C. And in this case, they are simply saying, I don't need to actually come on board and swab test the crew of your ship. But all I need to be satisfied of is that users of the port like you, i.e. foreign ships, present a risk of transmitting COVID. So we say, first of all, the suspicion that foreign ships were transmitting COVID was a reasonable suspicion. And secondly, where you suspect that foreign ships or class of users are or may be transmitting COVID, it's perfectly reasonable to do what the authorities did in this case, which is, number one, to introduce a stringent testing procedure, and number two, to have a lockdown until the testing procedure can be put in place. So I come back to the way in which Mr. Vinal put his case on this. He said, ultimately, you've got to ask yourself, what did this have to do with this ship? He said it's got nothing to do with this ship because the relevant steps would have been taken in any event. And the answer is that's deft advocacy, but not good analysis. It's perfectly true that this was a measure which was implemented because of the risk from foreign ships generally. And so it is also true to say that the coming of this ship to the port was not a but-for cause. Right? It wasn't a necessary cause of the rule that was implemented, but it was a contributing cause. Okay, so the reaction of the authorities in requiring this was because foreign ships like this one were using the port. So insofar as it's suggested in the owner's argument that the critical point is whether this would have been implemented, would or wouldn't have been implemented if this ship had not come, we say that's wrong. What you have to say is, was this a reasonable response to the risk posed by a class of ships of which this ship was one? Okay, that's all we say about off-hire. And I come now to the agreement to go to Porto Alegre. And as you've understood, our case on this is very simple. We, Ms. Chen, asked the owners whether we could go to Porto Alegre, and they agreed, and the ship then went to Porto Alegre. And the owners can't now complain that they suffered a loss as a result of that. You can call this an oral amendment or an oral addendum or whatever you like, but when two commercial managers agree that a ship will do X or Y, that is binding, and one party can't complain afterwards that they wish they hadn't made that agreement. So the question then is, what do you find on the facts that the parties agreed or said to each other in that critical conversation and as a result of that critical conversation? And in a large part, of course, we acknowledge that that depends on your impression of the witnesses. And although, of course, in counsel like in cases like this to tell you what your impression should have been, I'm not going to try to do that. And therefore, I'm not going to say anything about the straightforward and frank way in which Ms. Chen gave her evidence, nor about the simplicity and clarity of the way she said what she said. I merely say this, that no criticism could be levelled at her as someone who was not giving careful and considered evidence. But I feel I have to say something about Captain Nelson's evidence. This was a witness who signed a statement that he said he wrote, in which he claimed that he was the master of the ship at the time. And there was, in my suspicion, no credible or clear explanation of how on earth that happened. And I put to him, I hope fairly, that I asked him, was this because you wanted to give the impression that you were just a seaman and not in charge of the contractual negotiations? Well, he denied that, but I ask you, what other explanation is there for what happened? So I come then to the findings of fact that we ask you to make, and they essentially comprise 3 points. First of all, Ms. Chen asked for permission to go to Porto Alegre. The ship was days away from having to go to Porto Alegre. She said we were exploring options, and I think Captain, I hope you'll find that Captain Nelson said essentially the same, that at this stage she was asking for permission to go. She wasn't giving an order. Second point, we invite you to find that he said yes, subject to checking with my owners. Okay, that was where the witness's evidence converged. I asked him whether he reserved his rights, and he was vague on that point. He said, well, we sometimes use words like subject to charter party. He didn't say, in the way that it's phrased in his statement, I said that's out of the charter party and I'm reserving all my rights. What he said in his oral evidence was, I said yes, but I'd need to check with my owners. So one then gets to the third point. What is the effect of an agreement where Ms. Chen says, can I go to Porto Alegre? He says, yes, though I'll have to check with my owners. And that agreement, we say, by the way, is reflected in the email exchange afterwards. and then subsequently an order is given to go to Porto Alegre and the vessel goes there. Well, the effect of that is a classic Brogden Metropolitan Railway. That is the negotiation which is concluded by conduct when the ship does what the parties have been discussing. And we invite you to say that it was an agreement made orally, subject to a condition subsequent that the owners approved, and that approval was communicated by conduct. That submission, we say shortly, is consistent with both witnesses' oral evidence. It's consistent with the subsequent exchange of emails, and it is consistent with the subsequent conduct of the parties in giving and accepting the order to go. If Captain Nelson had really thought that there was an outstanding untied up issue about whether this was going to go, he would have been back on the telephone or back in email saying, okay, but I'm afraid it's another $100 a day on the hire. The fact that he didn't indicates that he, like she, regarded the deal as done, subject to approval. And I say in that regard, you will remember Miss Chen's evidence in which she says, look, I have to be very prudent. I can't, as Mr. Vinyl was suggesting to her, just go on a wing and a prayer. It's not up to me to say, oh, well, you know, as long as you're not objecting, it's okay, it'll all be all right for the night. He says, she said rather, I had to be confident that there was a deal because I know in shipping, if you don't have a deal, there's an endless dispute. Right, well, that then is all we say on that. And I say nothing more with regard to the fallback Kanchenjunga case than I said in opening. That if there was an agreement, that is a binding agreement. And this is not a case of an order taken and accepted without intention to modify the terms of the Charter. Those are our submissions on point 2, and I hand over the baton for point 3 to Mr. Hayne.
Madam President, in the remaining time, I wish to make 2 submissions. The first submission is the critical principle of law is that damages for breach of contract should put the claimant into the position they would have been in had the contract been formed. The second, closely related submission, that had this contract been formed, the owners would have earned $140,000 more than it did earn because they would have delivered it, the vessel, that is 14 years earlier into the following charter. Charterers have already paid the sum of money, and that is why owners are not entitled to any further damage. Turning to the first submission, the question in this case is whether the owners are entitled to damages on the basis of the difference between the charter rate and market rate, irrespective of what they in fact did with the vessel. The answer is that they are not so entitled, because the relevant principle of law is the compensatory principle. The normal market measure, which the owners argue for, is, in the vast majority of cases, a very useful shorthand or a shortcut. But it is not the complete answer. And this is one of those cases which is not amenable to using that shortcut. If any authority is necessary for the proposition that I seek to advance, the golden victory is a useful starting point. The owners in that case were not entitled to damages on the basis of the market measure. In circumstances where charterers had redelivered the vessel early, and the question for the House of Lords was whether the ship owners could recover damages on the basis of the normal measure in respect of the remaining 4-year charter period, even though only 14 months after redelivery, the charterers would in any event have been entitled to cancel the charter because of the outbreak of war. The relevant principle was set out at paragraph 29 of the judgment, which is at page 71 of the bundle. If you zoom in at paragraph 29, middle of the paragraph, Lord Scott says, the fundamental principle governing the quantum of damages is long established and not in dispute. They should compensate the victim for the breach for the loss of his contractual bargain. Then he cites Baron Clark and Robinson and Harmon, and goes on to say that if the contract is a contract of performance over a period, whether for the performance of personal services or supply of goods, or as here, time charter, the assessment of damages for breach must proceed on the same principle. Namely, the victim should be placed, so far as damages can do it, in the position he would have been in had the contract been performed. Another way of articulating the very same point is on the next page, paragraph 30, where Lord Scott says, just the top left-hand corner, that the claimant is entitled to the benefit of the contractual rights he has lost, and not the benefit of more valuable contractual rights. Now, the case that my learned friend seeks to rely on is the Achilles. However, as Ms. Hoffman fairly accepts, it is the inverse of our case. What happened in the Achilles was that the House of Lords held that the ship owners were limited to the normal level of damages, so that they could not recover more money in respect of a fixture that they lost, which they had managed to fix at above market rate. And the reason the House of Lords concluded that was because they said that this follow-on fixture was unforeseeable. So in that case, the House of Lords held that the normal measure of damages provides a ceiling. Now what owners seek to do in the current case is to say that the normal measure also provides a floor. And that proposition is factually inconsistent with the decision in the Golden Victory. If the normal measure provided a floor, the Golden Victory would have been decided the other way. Indeed, Lord Bingham, who my learned friend relied on, would have been in the majority in that case. But he was in the minority, and it was Lord Scott who was in the majority. My learned friend sought to distinguish Golden Victory on the basis that a greater degree of confidence would be necessary. Because she said, well, it was not necessarily the party's contemplation that there would be this follow-on fixture at the time of entering into the charter party in dispute. But of course, that can't be the critical distinction, because at the time of entering into the charter in the Golden Victory, the parties had no idea what was going to happen in Iraq. They had no idea that the Second World War was going to break out, and it was definitely no more foreseeable than in this case that they would enter into a follow-on fixture. And that brings me very shortly to the second submission, on which I luckily don't have to say very much, because if we look at the agreed facts in the bundle, in particular page 7 of the bundle, zoom in on paragraph 17.1, we can see that it is agreed between the parties that the charterers would have delivered the vessel into the long-term charter on around the 4th of May, had the vessel been redelivered by my clients, when she should have been redelivered. In the event the vessel was delivered 14 days later than the 4th of May, they therefore lost out on the opportunity of earning higher for those 14 days at the higher rate. And my clients had already paid that sort of money. Those are the $140,000. So the conclusion is that any other measure would overcompensate. It would lead to a windfall, or in the words of Lord Scott, it would compensate them for a contractual right they did not in fact lose. The contractual right to trade the vessel in the market. In circumstances where that's not what they did. They were never intending to do that. They were going to put the vessel into follow-on charter 14 days earlier than they had a chance to, and that's the right for which they had been compensated. Unless I can be of further assistance. That concludes my submissions of issue number 3. Any questions?
Yes, I've got one question for Mr. Kenny. Mr. Kenny, can you explain why you say precisely it was the fault of the vessel in causing this delay?
Yeah. The answer is that the question involves a false premise, which is that it's necessary for us to establish the vessel as at fault. It's axiomatic that off-hire is not a fault-based regime. It depends on responsibility, it depends on events which may have nothing to do with either party's fault. And in this case, we're ready to say there was no fault on the part of this vessel. But the event that occurred was one which was within the clause.
Thank you.
Well, gentlemen, and madam, given the time, I'm not going to reply.
Thank you very much. That therefore completes the submissions. Just one point, perhaps a detail on costs. It seems to me that there are a number of different variations of outcome on the issues that have been raised, and I wonder therefore whether perhaps the appropriate position may be to simply reserve costs rather than make any submissions on costs.
We're content for you to do so.
As are we.
Thank you very much, and I'm grateful to both parties for the very clear and timely way in which you put your cases to us.
Thank you very much. It's now time for a second poll, and as I may not be able to see it, Ms. Hoffman will be able to interpret the poll, but you're now invited to register your vote in relation to the end poll. So I hope that all the participants will do that, and we can compare that with the results of the first poll. Unfortunately, you may not have caught those, but we can give that information to you. So if you now kind of like to register your votes for the end poll, we'll take that now.
Thank you. The poll is running now. I'll just wait until everyone has had a chance to vote, maybe a few more seconds. Votes are still steadily going up.
Do we have a result?
We now have 181 votes out of 319. There's still some votes coming in, but we can also close the polls now if you want to do so.
I mean, let's say if you're still sitting on the fence, can you register your vote within the next minute, and then we'll declare the result.
48-52, very auspicious numbers. So.
I'll share the results in a moment. I think we can close it now, probably.
Thank you. So if you could deliver the result and also...
Absolutely. I'll first repeat the result from the first poll, which we opened just before arguments started. 134 of you voted. Thank you for that. which was roughly half of the participants at that point. And we just asked a general question of who you thought had the better arguments overall. 74% thought owners and 26% thought charterers. Now, having listened to all the arguments, the race is much closer. We have a total of 191 votes out of 319 attendees. And it's split in 3 issues. So having listened to the arguments in full, was the vessel off hire from 16th to 30th of April? 49% think yes, 51% think no, so very evenly balanced. Second question, was there an agreement to amend the charter party to allow discharging at Porto Alegre? 57% think yes, 43% think no. And third issue, are owners entitled to the market rate or the follow-on charter rate as compensation for late redelivery? Market rate, 49%, and follow-on charter rate, 51%. So again, very closely matched.
Thank you very much indeed for declaring the result, Ms. Hoffman. It's now for the tribunal to give their verdict. I was asked one question, namely, will there be a written award? I'm afraid that we're not expecting the tribunal to produce a written award, but there will be an extempore verbal award, something which we're not often treated to these days, but I'm afraid we will not have a written award. That's not envisaged. Thank you. So if I can hand back to Mr. Aston, please.
Thank you. Well, as has been said, extempore awards of this nature are very unusual. But I'll provide a summary of the conclusions that the tribunal reached. On the first question of off-hire, the charterers rely in particular on the provisions of clause 15 of any other cause preventing the full working of the vessel. They say that this is designed, or that the regulations at Porto Alegre were designed with reference to ships like this vessel. And it was aimed at the class of ship of which this was one. And for that reason, they identify the vessel with the lockdown that occurred. The owners emphasized the fact that the circuit breaker cause was extraneous to the vessel itself. It would have been made wherever the vessel was, and that the decision had nothing to do with the vessel, which was at all times in itself efficient. Now, in reaching our conclusion on this, we accept, as stated on page 50 of the Laconian confidence judgment, that a vessel's full working may not be prevented. So let me read the section. A vessel's working may be prevented by legal as well as physical means and by outside as well as internal causes. However, we consider the essential passages of the judgment of Rix to be on page 151 of the judgment, page 40 of the bundle, where he says, it is to my mind natural to conclude that the unamended words, any other cause, do not cover an entirely extraneous cause like the boom in Courtline or the interference of authorities unjustified by the condition or reasonably suspected condition of ship and cargo. And furthermore, later on that same page, the authorities suggest that where the authorities act properly or reasonably pursuant to the suspected inefficiency or incapacity of the vessel, any time lost may well be off hire, even in the absence of the words whatsoever. In finding that the vessel was not off hire, we focused on the fact that there was no suspicion of anything in regard to this vessel in particular. The vessel was not even within the minds or contemplation of the authorities when the lockdown period was imposed, and we regard the class of vessel to which it is said that this vessel belongs as being far too broad to impact on the off-hire provisions for this particular charter party. And we note in particular the reference made by Mr. Ricks, Justice Ricks, in his judgment to the condition or suspected condition of the ship, or to the inefficiency or incapacity of the vessel, by which we understand it to be referring to the specific vessel rather than the generic term of any vessel, which is to what the regulation applied. So we conclude on point one that the vessel was not off hire throughout. Because of that, it is not strictly necessary for us to determine the second issue as to whether there was an agreement to vary the charter party. However, we would normally give an indication of what our views are on that point. And we're not convinced by the evidence of Captain Nelson that it seemed clear to us that the master proceeded to Porto Alegre, and that there was no reference at any stage to any reservation of rights. Now, Captain Nelson is an experienced shipping man, and he was clearly aware of the potential value of a request to vary the charter. And it seems to us unlikely in those circumstances that if he was looking to reserve his rights, he would not have made some mention to that. The owners invite us to look at what passed between the parties in writing. We are more inclined to look at the events that took place, which is that after this conversation, the vessel proceeded into Porto Alegre without any reservation or comment. And therefore, we conclude that there would have been an agreement that was communicated by conduct in the vessel proceeding to Porto Alegre. On the third point, that of quantum, we are inclined to give effect to what we believe is the compensatory principle. The damages are intended to put the party in the position they would have been if the contract had been performed. It was suggested by the owners that in some way they lost an opportunity of gaining the market rate for 14 days, which perhaps suggests that they say there would have been some employment that the vessel could have taken at the market rate for those 14 days. However, it was agreed between the parties in the statement of agreed facts that the vessel, in fact, would have gone straight into the follow-on charter, and there was no evidence to suggest any employment that the vessel could have taken within the 14 days. So that there was not a market to wit that was open to this vessel. Our conclusion, therefore, on this point is that the owners are entitled to what they've already received, which is the difference between the charter rate and the follow-on rate, and not the market rate. Now, those are our findings and conclusions. Costs are reserved, and the outcome from the very close results I see is accepted and acknowledged by a large number of you, but there are clearly quite a few who might not have agreed with our conclusions. Yeah.
Thank you very much indeed, Mr. Aston. It's now an opportunity perhaps to deal with one or two of the questions and answers which have come in. Quite a number of them came in only quite late in the proceedings, and we may well not be able to answer all of them. We did originally intend to wind up at 12 o'clock, but I think there are perhaps one or two questions which we could take, and we can also look at the other questions which have arrived in writing, and it may be that we can attempt some answers to those in writing in due course. But one question which arose was as to whether there was an issue or a point to be made that there was no consideration for the alleged agreement to allow the ship to go to Porto Alegre. And I wonder if Council might like to comment on that. Mr. Kenny, you're looking.
I've been in practice for a reasonably long period of time, and I've never seen a consideration argument succeed. I think the theoretical response is it's an alteration of mutual promises. So the consideration is that each side undertakes to the other that they will give orders for and will go to the port. And those mutual promises are sufficient to constitute consideration. The practical answer is that if your only answer to a case, to a point, is consideration, you're in all kinds of difficulty.
Could I ask another question? Is there an issue potentially here as to whether the port could be regarded as an unsafe port if it was declared, quarantine was declared in that port? Is this an argument which you've encountered? Mr. Vinyl?
Well, I'm not sure that would work terribly well on the timing here, and therefore might be quite difficult. I think there's quite a lot of disagreement as to COVID and unsafe ports, and so I'm not going to risk a view on that.
I think I should also add
consistent with Mr. Vinyl's view that this was completely unexpected, you might say it was prospectively safe. This absolute thunderbolt came out of the sky, because this is my view that, of course, COVID is to be expected everywhere at any port. Then I can see an element of legal danger might be arguable, although it's not an attractive argument.
I think that gives me the cue to say that nothing which we say in the course of these proceedings should be taken as legal evidence on which you should rely. And if you do want to have definitive advice on this or a definitive decision from a tribunal, I'm afraid you should address counsel or solicitors in the normal way. One other question which came up is, and these cases have become rather frequent recently, I'm dealing with one myself at the moment, is as to whether the use of the BIMCO clause which has been developed to deal with COVID and crew changes and so on and so forth might have an impact had it been adopted by the parties in this case. I wonder if anybody would like to offer a view on that.
I think most clearly that there would have been more avenues for argument than there are now. Whether or not it would have reached clarity is different, entirely speculatory, but at least there would have been clauses dealing with the specific circumstances rather than having nothing and having to construct something from scratch.
What I had seen quite frequently is that there are old-fashioned clauses dealing with quarantine, for example, in addition to clauses 8 and 15 of the New York Produce Form, but they don't necessarily address the sort of circumstances we're dealing with now. I think that there is some evidence that charterers and owners are now developing more specific clauses in the light of their experience with COVID.
Yeah, I should just say that there is a BIMCO clause, and we, and I think Anna may be about to chime in on this, as the designers of this problem, made a decision, however interesting it might have been for the market for us to debate that clause, that it was not going to be a profitable subject matter for mock arbitration, because it does what it's supposed to do, namely it makes the whole position clear. And what we needed was the very opposite of that.
If I might just chime in briefly here and plug for a different talk which happened on Tuesday, exactly on the BIMCO clause, which I understand will also be recorded. And for people who are interested in that, they can look at that. BIMCO is currently redrafting the clause. And the real problem with the current clause is that potentially the definition of the disease is very wide, and the definition of the affected area is also very wide, which might potentially mean that COVID is everywhere and everything's an affected area. So that's currently being redrafted to suit a pandemic situation more. If you're really keen, you can listen to that talk as well.
Can I just ask one other question which was raised, where one of the audience asked, on the basis of paragraph 9 of the agreed facts, the vessel tendered her notice of readiness at Porto Alegre on the 15th of April, and therefore the charterer already admitted by the notice of readiness that the vessel was ready to discharge, and such agreed fact contradicts the argument of off-hire. Would counsel offer any thoughts on that? The tendering of notice of readiness, does that happen?
The fact that a ship is ready to discharge doesn't in any way prevent a subsequent interruption to discharge constituting an off-hire event.
Another question was as to whether, if there had been already a confirmed COVID case on the Buena Vista, on the ship, would this change the position for off-hire?
I think it would make my position more difficult presentationally, although I think I would say that it shouldn't make any difference, actually, because all the arguments I put would still apply. But my word, it would make it a less attractive case for owners to run.
Thank you. One question from a gentleman about the pleadings or the form of submissions. He points out that the submissions which have been made in this case, the statements of case, are very much in the traditional English common law form. And would it be appropriate, can the parties submit in the style of memoranda with evidence referenced in the pleadings or memorials? Well, perhaps I could just offer a comment on that. In LMAA cases, it is very much the norm that the traditional common law form of pleading is adopted, and it will very much therefore depend on how the claimant frames its pleadings in the first instance, and the respondent will respond normally paragraph by paragraph. There is no hard and fast rule. It is not. There is no rule against submitting memorials as such, but the form of submissions which are encouraged and indeed required in LMAA proceedings do require evidence to be presented with the submissions. Therefore, there is an element of upfront disclosure, of similar, perhaps in some respects, to the type of disclosure which you would find with a memorial. But I think that's an answer to that.